When you make a will, you're putting your wishes down on paper, who you want to inherit your assets, who you'd like to look after your children, and so on. But have you thought about who actually takes charge of everything after you're gone? This crucial role falls to the person or people you appoint as your executor. Now, their legal responsibility is significant. They gather all your assets. That's everything from your property and bank accounts to your investments and even personal belongings. They then use those assets to pay off any debts, bills, and taxes, including any inheritance tax, if that applies. Finally, they distribute what's left, inheritance, to your beneficiaries that you've named in your will. Essentially, they execute the instructions that you left behind. Choosing your executor carefully is one of the most important decisions that you'll make when writing your will. It really helps make the process much smoother for everyone involved during what will inevitably be a very difficult time for your loved ones. So, who can you choose? Your executor must be aged over 18 years of age and have the mental capacity to take on the role. Now, the most common options are as follows. So firstly, friends and family, often called lay executors. This could be your spouse or partner, an adult child, siblings, or trusted friends. Number two, you can appoint professionals such as solicitors, professional will writers and estate planners, or accountants who bring specific legal and financial expertise. And third, there are trust corporations. These are specialist companies often associated with banks set up specifically to act in this capacity. How many should you appoint? So you can just name one executor, but it's often wise to appoint two or more. This helps share the workload and provides backup if one person is unable to act when the time comes. It's also a good idea to name substitute executors in your will. For example, I name A and B, but if either of them cannot act, I appoint C. Just be aware that legally only up to 4 executors can apply for the grant of probate for somebody's estate. Now let's look at the key factors to consider when making your choice. So trustworthiness is absolutely paramount. Your executor will have the control over all your assets, so you need complete confidence in their integrity. Next, consider their willingness and ability. Are they generally happy to take on this responsibility? It really is vital that you talk and ask them first. Do they have the necessary skills, organisation, handling paperwork, dealing with official bodies? Do they have the time? Even for the simplest estates, the process can take many months. And are they resilient enough to handle the potential stress or complex family dynamics? Now, ideally, they'll be based in the UK, and that will make administration much, much easier, although it's not strictly essential that they are based here in the UK. Dealing with UK assets from abroad can add significant layers of complexity. I also advise that you consider their age and health relative to yours. Are they likely to be around and capable when needed? This is another reason why appointing substitutes is a good plan. Also, be mindful of potential conflicts of interest. It's very common for beneficiaries to be executors, I should add. So, for example, naming a spouse or an adult child as both an executor and somebody to benefit from your estate. However, if you're appointing just one beneficiary out of several, say, for example, one child is an executor out of 3 that are all your beneficiaries, then this could potentially cause some friction with the other beneficiaries. Sometimes an impartial executor in those situations could be helpful. So finally, think about the complexity of your estate. If your affairs are relatively simple, perhaps just a house and some bank accounts, a lay executor might manage perfectly well. But if your estate is more complex, involving business assets, or if you're lucky enough to have an overseas property, complex trusts, for example, or if you anticipate potential disputes, professional expertise might be highly beneficial. Now let's briefly compare lay versus professional executors. So lay executors, so your family and friends. Now, they don't charge professional fees, although they can claim reasonable expenses incurred during the process. So, for example, postage or court fees. Now, they know you and your family well. However, they may lack the necessary expertise or time and could find the process emotionally difficult, and there's potential for family friction. So professional executors now, like solicitors, will writers, or trust corporations. Now they bring expertise, impartiality, and efficiency, especially with complex estates. They're also insured. The main downside, of course, is that they charge some fees, usually based on the time that they spend on your estate or a percentage of the total value of your estate. If you appoint a professional in your will, you will need to include a clause that authorizes these fees to be paid from your estate. One absolutely crucial final step: always speak to your chosen executor or executors before you name them in your will. Confirm that they understand the role and are willing to accept the responsibility. So, in summary, choosing your executor is a significant decision. Think carefully about who you trust implicitly, who is capable of handling the practical and emotional aspects, and what the specific needs of your estate might be. It's a lot to weigh up, and it's a point that we always discuss fully with our clients while dealing with their affairs. So if you'd like to talk through the best options for your specific situation, Westwood Estate Planning is here to help. You can find our contact details on our website, and I thank you so much for watching this video, and have a great rest of your day. Bye for now.